Good afternoon. As the chair of the Animal Law section, along with Jacqueline Thomas, our treasurer, I am pleased to introduce today's CLE to discuss National Pork Producers Council et al. V. Ross, Secretary of the California Department of Food and Agriculture et al. The issue under question was whether Proposition 12, the California law that prohibits the in-state sale of uncooked meat products from pigs raised according to standards that do not meet California's animal welfare standards, violated the Dormant Commerce Clause. The Supreme Court issued its ruling on May the 11th, upholding Proposition 12. The case has important implications for animal welfare nationwide. Our speakers today are Rebecca Carey, a senior staff attorney at the Humane Society of the United States, where she has worked since 2010 and focuses primarily on farm animal law. She contributed to or served as lead counsel on many of the cases challenging California's Proposition 12, including this case. She is a 2009 graduate of Northeastern University School of Law and a 2005 graduate of the University of California, San Diego. Rebecca currently co-chairs the DC Bar Animal Law section and lives in Maryland with her 3 rescue cats. And we're extremely excited to have her speak today. We also have Megan Boyd, who is assistant professor at the College of Law, Georgia State University since 2014, and a former animal law section chair. Megan received her law degree from Mercer University School of Law in 2008. She will discuss the implications of the Supreme Court's ruling upholding Proposition 12 for animal welfare in Georgia. Just a few housekeeping items. We have reserved time for Q&A with the panelists. Please post your questions in the chat, and Jackie and I will take turns asking them after our speakers have presented. We have applied for 1 general CLE credit, and some materials are forthcoming. We have also been coordinating this with the Constitutional Law section, who will be hosting a separate CLE to discuss the constitutional issues at play later this summer. I will now cede the floor to Rebecca to discuss the case.
Great, thank you so much for having me, and thanks for to everyone who's joined today. As Siobhan mentioned, I'm a senior staff attorney at the Humane Society, and this case has consumed the better part of a good number of years for me now. So I know there's going to be an additional panel getting into some of the more nitty-gritty constitutional issues here, but what I thought it would be good to do with you today is to give you a little bit of background on sort of how we got to a place where an animal law case ended up before the nation's highest court. So to understand the magnitude of the decision that came out this past month, I want to walk you back a little ways, and I'm going to start sharing my screen. All right. So many of you probably know that Proposition 12, the details of which we'll go over in a bit, was a 2018 law that addressed animal welfare. It also addressed some public health and environmental concerns, concerns that are associated with the extreme confinement of farm animals. And there we go. You know, Proposition 12, in a lot of ways, is like many other laws that seek to exclude products based on animal cruelty from a local marketplace. So I'm talking about restrictions on, for example, the sale of dogs from puppy mills, or the restricting the sale of trade in endangered species or in parts of endangered species, the sale of cosmetics tested on animals. But what I hope you come away from today is, I hope you come away with an understanding that the Proposition 12 litigation is and has been really more than that. It's got significant implications for our work to strengthen laws that protect animals, but also, you know, animal abuse almost never rides alone. The laws that are about animal protection are often integrally linked with laws about environmental protection, worker justice issues, pollution issues, things like that. So what was at stake here in front of the Supreme Court was huge. And I'm going to skip what I usually do. I sort of chat about some of the history, the early history of animal law, to just say that the animal abuse industry has really evolved a lot along with our laws and the types of laws that protect animals. Today, most animal abuse is sold to someone. I'm talking about fur salons or cosmetics counters, the neat little packages that you see at the grocery store. The fact is that because of sort of the way that our modern marketplace works, consumers are often buying products without having any idea how those products were made and what kinds of cruelty or other harms went into them. And that's presented a lot of new problems. So this increased ability to transport products anywhere in the country and the world has increased the opportunity to exploit animals. And it's a problem that's new to sort of the last century and growing today. So for example, dog breeders who used to basically be selling their dogs to neighbors nearby who could see where those puppies were raised and knew the farmer who had reared the dogs, those unscrupulous producers are able to have a litter of puppies, or let's say several dozen, raise them in tiny barren cages like this puppy mill you see on this slide, and then transport those puppies to buyers across the country via the internet or elsewhere. And those consumers have no idea how that cute little dog was raised. And that leads to a whole host of other issues on breeders we don't have time to get into today. But so in other words, producers are really able to amplify their cruelty for profit operations by taking advantage, by being able to produce their products in one place and then sell them elsewhere, far and away from where those products were produced. This is, for example, a map of the pork industry in the United States as of a couple of years ago. You can see it's very concentrated in certain areas of the country, and that's largely because producers are trying to produce their products in places where there aren't a lot of laws regulating, environmental or animal concerns, other things like that. So let's skip that. So we've seen a proliferation of new types of animal laws that restrict the sale of products of cruelty. And I mentioned a few already, but some others that you can see on this slide, laws related to fur sales, laws related to force-fed foie gras. The Supreme Court actually also just denied cert in a foie gras case that we won't talk much about today. Trafficking of fins from live fin sharks. So this is sort of the scheme that Proposition 12 fits in, these types of laws that restrict the sale of cruelly produced animal products. And so that's how we get eventually to Prop 12, but to tell you more about that, I need to tell you the story of the laws real quickly that came before it. So in 2008, California voters passed a law called Proposition 2, and what that did was to say that eggs and veal and pork produced in California need to come from animals who have the ability to stand up, turn around, and lie down without hitting the bars of a cage or another animal. Really radical animal rights stuff, I know. As you can imagine, most Californians, whether they ate meat or animal products or not, were horrified to know that animals couldn't already engage in these very basic freedoms of movement. So the law overwhelmingly passed by the highest percentage of any ballot initiative in California history. 2 years later, the state passes a bill called AB 1437, which says that all eggs sold in the state of California, no matter where they come from, need to come from conditions that are compliant with Proposition 2. So those same sort of freedoms of movement. And there were multiple lawsuits over Prop 2 and AB 1437. The earliest suits were brought by mainly by the egg industry. Those were all dismissed one after another by the lower courts. These were often about constitutional vagueness. In other words, egg producers saying that they didn't know what it meant for a bird to be able to stretch her wings and turn around in a circle. And I like to put this quote up here from one of my now favorite district court judges saying, basically, are you kidding me? Proposition 2 establishes clear standards, and you don't have to have the investigative acumen of this old 1970s police detective Columbo to determine if an egg farmer is in violation of the statute. So after producers themselves lost their cases, multiple states attorneys general sued. Their suits were also rejected on grounds that the attorney generals were essentially improperly bringing the cases, that they were stepping in on behalf of just a handful of producers who could bring those suits in their own right. It's a whole other issue, this theory of standing that they brought these cases in, but they were universally rejected. They tried to bring their case directly in the Supreme Court as well, an original jurisdiction case, and that was rejected as well. So that's really how we get to Proposition 12. So Proposition 12 effectively builds on this lengthy history of humane laws in California. And in some ways, Proposition 12 looked a lot like Proposition 2. It said that animal products had to have the covering those same three species, pork, veal, and egg-laying hens, needed to have certain standards attached to them if they were going to be sold in California. So it's a sales law like AB 1437, and unlike Prop 2, it's a sales law saying that no matter where these products are produced, if a producer wants to sell them in California, they need to meet those same Prop 2 behavioral standards, the lying down, standing up, turning around in a circle. And also, in addition, there were space requirements associated with each species. So for example, pork sold in the state of California must come from animals who are not confined in a cruel manner. And that includes that that mother pigs need to have at least 24 square feet of space per animal. And what that does is effectively mean that gestation crates, which are approximately 2x7 large metal crates that sort of barely fit around a pig's body, are effectively prohibited by this measure if the products are going to be sold in California. And you're going to hear me keep saying that because it's an important part of this case. So again, this ballot initiative passed overwhelmingly in California by very similar margins to Proposition 2. And I should mention that California is not the only state to have laws like this. There was a very similar law in Massachusetts, that's question 3. And since Proposition 12, more and more states are starting to pass laws like this, either by ballot initiative in states that have that process or directly in their legislatures. You can see here a map that I believe is of 2022. I really need to label a date on this map of states around the country that have some combination of either sales laws or production laws regulating farm animal products in the state. So the first group of pork producers who brought a challenge against Proposition 12, and all of these cases have been brought by pork producers against this latest California initiative, is a group called the North American Meat Institute, or NAMI. And they asked the court for an immediate injunction of Proposition 12 to stop it from going into effect. The Humane Society, along with several other allied animal organizations, intervened to defend this law. We were the ones who wrote it. We were in a good position to defend it and help a court be able to understand why this law was constitutional and why Californians had voted for it. And so NAMI's request for a preliminary injunction was denied by the district court, and that was upheld by the appellate court. The Supreme Court refused to take that case last year. So that did not stop the pork industry. Very shortly thereafter, after NAMI filed its case, a very similar group of pork producers filed a case in a very similar, on very similar grounds in a neighboring district court in California. And that is the National Pork Producers Council, who is the litigant in the Supreme Court case. Again, HSUS and our partners intervened to defend the law. We filed motions to dismiss. The lower court granted them. The Ninth Circuit upheld that, and NPPC appealed to the Supreme Court. In March, we learned that the Supreme Court had agreed, this past March, we learned that the Supreme Court had agreed to take the case. It was heard in October, and we just got a decision in it in May. So this past, I don't know how long, has been taken up with briefing and strategizing about how to convince the highest court in the land to uphold this California law. And it's been an uphill battle. So brief look at what the Pork Council was arguing in this case. Really, what their core argument is that California cannot prohibit out-of-state producers from selling their cruel products in the state of California. In short, they're saying that pork producers using cruel methods like gestation crates have an absolute right to sell their meat in California or anywhere else, no matter what kinds of abuses were committed in getting that meat to the market. And that any state that feels otherwise, because its citizens object morally, because it is a less safe and healthy product for any other reason, that states are powerless to exclude these products. So what's the constitutional basis for that? Well, the constitutional basis is the so-called Dormant Commerce Clause, which does not exist anywhere in the Constitution. As you might remember from law school, what does exist in the Constitution is the Commerce Clause, not the dormant one. And the Commerce Clause is, of course, what grants authority to Congress to regulate trade between the states. The Supreme Court has long held that this grant of authority to Congress implies some limitation on state and local legislation. But I should note that there have been multiple justices who have questioned this doctrine altogether. Justices like Thomas and Gorsuch, who are on the court now, and the late Justice Scalia, who called the Dormant Commerce Clause a, quote, judicial fraud. Okay, so what exactly are the limits on state legislation under the Dormant Commerce Clause? Don't worry, I'm not going to explain this crazy chart on the left. That is mainly to show that the doctrine is a mess. And we think that a large part of the reason the court took this case is to maybe provide a little bit of clarity on this doctrine that has a lot of intersecting parts. It's kind of like a Rubik's Cube. We're not going to go through it all now. But in general, what is well accepted is that the Dormant Commerce Clause means that states cannot regulate commerce in three different ways. They can't discriminate against out-of-state participants. So, for example, they can't pass a law that gives more favorable sales conditions to in-state producers than out-of-state producers. They also cannot regulate commercial transactions that occur entirely outside their borders. That's what's known as extraterritorial regulation, and it's a big no-no. But I should say that the Supreme Court has repeatedly said that first thing I mentioned, the discrimination piece, is what the Dormant Commerce Clause is really all about. That's reflected in this month's Supreme Court decision as well. The third thing that states cannot do is they can't impose through their laws a substantial burden on interstate commerce, a substantial burden that outweighs the local interest in that a state has in passing its law. Okay, so what NPPC, the Port Council, was really claiming in this case was mainly that second thing I mentioned. They didn't have a discrimination claim here. Again, that's the main thing that the Dormant Commerce Clause is trying to root out. Their main argument was that states can't, that what Proposition 12 was doing was regulating extraterritorially. They were saying that the only possible purpose of Prop 12 is to regulate products that are produced elsewhere to bring into California, and that then that's effectively, that's necessarily extraterritorial, that these effects are extraterritorial. And so I should say, they also had a claim on that last one, the substantial burden claim, but that was sort of their, their secondary claim. The extraterritoriality piece was the biggest part. But numerous federal courts have previously concluded that states do have a right to cleanse their markets of products that their citizens deem to be unacceptable. And a lot of the laws that HSUS has helped to write and pass over the years across the country have been in this vein. So laws like the ones I mentioned, restricting the sale of shark fins or foie gras products, fur sales, all those different things. The reason that those are constitutional and have been upheld by many federal courts is because they don't directly control any activity outside the state. All they're doing is saying that if you choose to sell that product in our state, you need to comply with certain standards. It's not forcing anyone to do anything. And NPPC effectively admitted that what they were asking the Supreme Court to do was to sort of undo these longstanding rules on extraterritoriality and expand the doctrine to a place it's never been. Effectively, and they're doing this despite the fact that the authority for the doctrine comes out of a grant of authority to Congress. But they're certainly not saying that they necessarily want Congress to regulate the welfare of pigs, or at least not exactly. What it really is a race to the bottom. What NPPC wants is a system in which the largest and most consolidated producers can produce meat in this efficient scale that they want to do it at, with no limits on selling their products. And so the case is really sort of about warping the constitutional doctrine in this area. And it's been a difficult fight. And so as we were developing sort of our strategy to fight this case, what we really wanted to do was come up with a 9-justice strategy. We wanted a brief that spoke to everybody in the court in one way or another. How am I doing on time, Siobhan?
You're good. You've got another 7 minutes.
Sweet. Oh, I sped right through that. That's great. Well, then I'll just say that one of the things that I thought was most interesting from sort of a practitioner level in this case was our amicus brief effort. And what I mean by that is that many Supreme Court cases, I'm sure you all know, have a lot of amicus briefs submitted on either side. This one had 27 submitted on our side, which the state of California, who we were working alongside on the case as another appellee, said they had never seen one with 27 briefs on their side. Being the first Supreme Court case I've worked on, I can't say the same, but it was a lot of briefs. And that was specifically in order to appeal to the justices from multiple different angles. So for example, one of the briefs was from a group of very well-respected public health and infectious disease experts. They made the case that Prop 12 addresses risks of food safety and public health by restricting pork products. They provided scientific evidence for the fact that more space reduces stress in sows, which mitigates stress-related negative impacts on sows and their piglets who are destined for slaughter, and that ultimately could have a positive effect on Californians' health and safety. health and safety, of course, is one of the very long-standing reasons that, with things that have been well within states' police powers to pass laws since the Constitution was formed. We also had briefs from the meat industry themselves, people who were able to say that they are working within the California confines and that they are able to produce pork that meets the California standards. And that was, I think, really effective in countering industry arguments that it was impossible or too difficult to produce products for the California market. We had briefs both from larger producers and from smaller farmers across the country. And the Supreme Court, in its decision in a footnote, noted those briefs specifically, saying that basically that the pork industry had a plausibility problem here for their substantial burden argument. They're saying that there's this substantial burden on interstate commerce, and yet all these producers seem to be complying with Proposition 12 just fine. We also had there was a brief submitted by some conservative constitutional scholars. And that brief really went into the details of some of the religious and longstanding moral rights of people to restrict products from their border. And I think that was particularly effective in getting some of the more religiously inclined members of the court to look at this in a different way. So I guess what I'm saying here is that this case created some strange bedfellows, but also some really interesting bridges between different groups, some of whom work together very often, like animal advocates and environmental advocates, and some less often, like big pork producers and perhaps scholars like these ones here. And so that was all to get these 9 fine people here to vote in favor of Proposition 12. And at the end of the day, the court affirmed the Ninth Circuit's dismissal of this case. In one of my favorite quotes from the case, they said that while the Constitution addresses many weighty issues, the type of pork chops that California merchants may sell is not on that list. So the court on the extraterritoriality claim actually voted unanimously in our favor and in the state of California's favor. The substantial burden claim is a little bit more complicated, and I'll save some of that discussion for when you all do the sort of more constitutional future panel that you're doing. I'm sure they'll want to get into that, but there were a lot of sort of concurrences in that opinion that makes it a little bit complicated. Well, this is great because this is actually where I wanted to end on this slide. A lot of people have asked me, what's next? What does this mean? I know Megan's going to get into some of that for what it means for sort of some industry players and others within Georgia. But one thing I wanted to flag is that there is a federal bill that has been introduced in one form or another several times previously in other sessions of Congress. Another form of it was known as the King Amendment, which was introduced by Steve King a couple of times, tacked onto the Farm Bill. Basically, Senator Grassley and others have said that they're going to introduce a version of this again. It's likely to be called the EATS Act, so keep an ear out for that. What the EATS Act would do is to say, it's exactly sort of that congressional override that I sort of hinted at before, and it's an attempt by the pork industry, now that they've lost in the courts, to go to Congress and say, okay, Congress, maybe we do need a law about the pork industry, but it's not actually a law that would regulate any kind of like confinement standards for pigs. Instead, what it would do is wipe out states' ability to regulate agriculture within their borders altogether. It's extremely broadly written, or at least the last version we saw was. We have yet to see the new language in this bill. But it's, much like if Prop 12 had been struck down, it could have had severe implications for other animal and environmental and agricultural laws. So too, could this have some very extremely scary negative effects on state laws and local laws all around the country aimed at protecting humans and animals within a state's borders. So that could probably also be another whole panel in itself, but I think I will end there for right now and turn it over to Megan, and I'm happy to answer questions later as well. So thank you.
Thank you, Rebecca. That was fascinating. Megan, to you.
All right, awesome. Thank you, Rebecca, so much for being here. I just want to echo Siobhan and saying we really appreciate you coming to talk to us today. As Rebecca noted, agriculture is controlled extensively at the state level. And one of the things that Justice Gorsuch's opinion points out is that Congress does have the authority to regulate certainly pork production and the treatment of animals pre-production, but it had up until now, chosen not to do so. And that was, a good part of his opinion was that basically the pork producers were trying to get the court to do what it wasn't in the court's power to do, which is, to strike this down. So anyway, because we know that agriculture is controlled extensively at the state level, and at least unless and until something like the EATS Act is passed, we're still seeing that happen. So I just want to talk a little bit about pork production in Georgia and whether and to what extent this opinion is going to have any impact on Georgia residents or consumers. So pigs actually came to Georgia through Florida. They were introduced by the Spanish settlers who came through Florida, and for a long time, beef or cattle was the primary livestock in this area. Now, in the mid-19th century, pork actually became sort of the primary meat that was eaten by most Georgia settlers, including people who lived on more of the sort of frontier, I guess, if you can call Georgia, any areas of Georgia frontier, but in the frontier areas and in settlements or towns. And during the antebellum period, husbandry practices started to take hold. And so at that point, more hogs were kept in farms and fewer were sort of free grazers. Also during that period, pork came to be considered a particularly good food for enslaved peoples. So there was quite a lot of pork produced for the purpose of feeding enslaved peoples, while white people generally had a slightly more diversified diet that included beef and chicken. Also important during this period is the ability to cure pork, which enables us to preserve it, ensuring that, we can have food throughout the year. So for quite a long time then, during the 19th century and even the earlier part of the 20th century, pork production was a big part of Georgia agriculture. And as we all know, agriculture is a huge part of the state of Georgia. So 1979, though, was the last year that pork production in Georgia was really a big deal. About 2.4 million head of hogs were sold in Georgia in 1979, most of those from smaller farms. And so the 1980s and 90s saw a change. The 80s, there was several years of drought and interest rate increases that resulted in many small farmers selling their farms. And this decreased the number of hogs that were produced in Georgia. Then in the 1990s, we start seeing the rise of industrial farming. Now, prior to the 1990s, most hogs had been auctioned locally in Georgia, but as those auctions stopped, it became more costly for Georgia pork producers to sell their heads of cattle. So therefore they became, the revenue decreased. And so pork production became not as lucrative. Also, the industrialization of farms saw hogs go from being raised outside in pastures or in dirt to being raised inside in buildings with environmental controls, which of course folks in the pork industry will tell you reduce disease and increase production, resulting in cost savings for consumers. But we also know that they make hogs' lives more miserable. So anyway, As of today, Iowa is actually, hence Chuck Grassley's interest, Iowa is the #1 pork producer in the United States. Nearly a third of the nation's pork comes from Iowa, which is about 33 million head a year. And Smithfield Foods, which many of you are probably familiar with, is the #1 US producer of pork, but a lot of US pork is actually exported to countries like China. We also export to quite a lot to Canada, but China is the main source of our pork exports. So Georgia now, even though it used to be a major pork producer in the country, is now way down on the national list of states that produce the most pork. Last year, in 2022, only about 40,000 head of hogs were produced in Georgia. And pork production and sale is now a really small percent of the state's agricultural revenue, somewhere in the range of 5, 6, 7%. Chicken and cattle are much larger sources of agricultural revenue for Georgia producers. Also now, most Georgia hogs are shipped out of state for processing. There are a few in-state processors here in Georgia, but most of those appear to only supply locally or maybe regionally. But there's just not a lot of evidence that any of the local meat producers are sending pork far outside the state. Maybe, maybe some in the Southeast, but most of it is staying in the state. So I think ultimately we're unlikely to see a large impact on Georgia pork producers as a result of this opinion. Now, certainly Georgia could follow California's lead and basically ban gestational crates. It's not going to do that. Being a large agricultural state, there's a loud minority of people in the legislature who are against any type of law that puts any conditions on agriculture. So we're unlikely to see anything like that happen here. Now, the question is, though, what effect is this going to have? As Justice Gorsuch notes, pork producers now have a decision to make, including those pork producers in Georgia, right? Some may choose not to serve California at all. They may choose to continue to operate in the way that they have. And if that way doesn't satisfy the requirements of Prop 12, then they may just choose not to serve the California market. Another option for pork producers is that they can choose to separate their California-bound pork from their other pork. So, an area in which California-bound pork is raised, and then a separate area for pork everywhere else in the country. And one thing we're not sure about, and I'm not an economist, so I don't know the answer to this, but one thing we're not sure about is how this cost increase is going to be passed on to consumers. It's certainly possible that the cost increase of getting rid of gestational crates, of giving hogs larger areas in which to exist before the baby pigs are born and before they're slaughtered, certainly this is going to cost more. And so, but what we don't know is whether this cost increase is going to be passed on just to California consumers, or whether it's going to be passed on to all consumers throughout the US. So I think the latter is probably more likely, just because it's, difficult to make those divisions. So I think, overall, we will probably at some point see a cost increase, probably not substantial, but a slight cost increase to all consumers of pork products throughout the country. But obviously this is going to have a huge impact for states like Iowa, where the producers are going to have to decide what they want to do. I mean, it's certainly possible that some producers will decide that they're not going to offer products in California anymore, and that instead they'll either ship those products to other states if there's demand for them, or otherwise, export them overseas. Again, China is a huge market for US pork, and that market continues to grow. So it's certainly possible that many producers who, producers like Smithfield may just decide not to serve the California market. But I think that that's highly unlikely. I think that what's going to happen is just that the costs are going to be passed on to consumers. And again, this includes folks who are raising cattle here in Georgia. But again, because cattle is not our primary agricultural export, not even the primary meat that we export, I think it's not likely to have a huge impact on Georgia pork producers. All right, Siobhan, that's all I got.
What a fascinating lesson, Megan. I did not know anything about pork in Georgia, so that was really interesting.
Yeah, like I said, it used to be a lot bigger agricultural product for us, but it's become less so, over the years.
Great. Wow. Well, we'd like to open it up to our members to post questions in the chat or your observations. And actually, I think what we're going to do is Jackie and I came up with a few ourselves, and I'm going to let Jackie start with some questions. But please, everybody, put questions or observations in the chat.
Thank you both, Rebecca and Megan, for your fantastic presentations. We really appreciate it. It's very fascinating. So my first question is directed towards Rebecca. What do you think made Proposition 12 different, in the sense that there have been other laws in other states that ban animal products that are deemed to be cruel, and these other states have made policy choices in that respect? But what is different about Proposition 12 that it made its way all the way to the Supreme Court?
Yeah, that's a great question. I think it's a number of things, but a huge part of it is the size of California. That's sort of the elephant in the room. And what, the reality is the sort of number of pigs that are destined for California is far different than the number of pigs destined for Rhode Island. So it's unlikely that if Rhode Island passed a bill like Proposition 12, that the pork producers would have fought it all the way to the Supreme Court. It probably wouldn't have been worth the resources. But what I think is just very interesting about that argument, that sort of California, that the effect is greater because of the size of the state is greater, is that it's flawed constitutionally, and Justice Gorsuch pointed to this because
that was one of my favorite parts of the opinion.
Yes, yeah. I'm glad you noticed that too. Yeah, it cannot be the in this federalist system, it just cannot be true that a size of a state determines whether they are able to protect their citizens and their marketplaces differently, than a smaller state. That's sort of antithetical to everything that the founding fathers were going for with the Constitution, right? So, so I think it's the size of the state that in part led to the sort of professed state of emergency in the industry, but it's also in part the size of the state, and sort of weighing that against, looking at what that really means, that led the justices to in part to realize that actually there's no constitutional problem with this law.
And I think to piggyback on that, because of the size of California, we see other states do what California does. We've seen other states sort of deal with foie gras and things like that once California does it. So, California, I think the animal food industry sees what happens in California, and that's a warning sign to them. And so they try, specifically to attack the California laws because they fear that it's, it's like a disease that's going to spread.
Yeah.
All right, we do have a question in the chat. This is from Catherine. Aren't the farrowing crates used only temporarily while the piglets are nursing? What will the prohibition on the use of farrowing crates do to piglet mortality due to crush and smothering by the mother?
Yeah, so I can address that one pretty easily. Prop 12 actually doesn't deal with farrowing. It exempts farrowing altogether. Gestation crates are different than farrowing crates. Gestation crates are used when the sow is pregnant with the babies. Farrowing is sort of a separate process and handled separately by the industry.
We have an observation from Deborah. She agrees 100% that influential Georgia lawmakers have no tolerance for any policy that might restrict any aspect of Georgia agriculture.
Yeah, so I was going to say, when Rebecca was talking about, the selling of animal welfare and, and animal cruelty, I don't know if you know, Rebecca, but here in Georgia, so there have been efforts for many years to get laws both banning the sale of puppies produced at puppy mills, and then efforts to get a state law that allows the sale of puppies produced in puppy mills. And so what's happened is that while both sides have not thus far been able to do anything at the state level, there have been efforts at the local level, to ban puppy mill sales. So, I mean, this is alive and well in Georgia. But again, because we are such a heavily agricultural state, and because the folks who represent those with agricultural interests are a very vocal group, the efforts to get laws, which seem, I mean, I don't understand why it's so hard to say you can't sell puppies from but our efforts at doing that have not been fruitful so far.
Yeah.
So, and again, that seems to be something that's not generally objectionable, and that affects a small number of people who are raising these types of animals, as opposed to other types of animals. But we've been unsuccessful at that so far. So, it's still very much a protectionist state for agricultural interests.
Yeah, that can make things, certainly some of these bills are easier in some states than others, undoubtedly. But I will just sort of add to that, and sort of on the more optimistic end of the spectrum related to that, with a lot of polling has been done on laws like Prop 12, and they show that the majority of people in both parties across the country, no matter what state they live in, would like a law like Proposition 12 in their state. So it could be one of those cases of, yes, some intractable sort of politicians in the legislature, but really the sentiment, I think probably, whether you're in a red state or a blue state or a purple state or whatever, I think polling's been pretty clear that Americans, even if they eat animals, want to see better treatment and are often willing to pay more for that too. And I was just going to add as well, while I'm talking about pay, that there is an interesting footnote in the Supreme Court brief pointing to a brief by agricultural economists who actually submitted the brief in favor of neither party, but who were formerly hired by the pork industry for similar studies. That amicus brief in the case does note that there could be some sort of temporary price fluctuations, but that most of those would probably be passed on to California consumers, and that, of course, there's no constitutional problem with that, and that that's what Californians voted for. I mean, it was in the text of all the voter pamphlets and everything that this might cause some temporary price increases.
Another question in the chat from Matthew. First, he thanks you for the great presentations. He was wondering if you see any strategies for legal animal welfare advocates to use this SCOTUS precedent in future lawsuits, administrative petitions, etc. So how can this be used for by animal welfare advocates?
Yeah, that's a great question. I can sort of start. I think in a lot of ways, as great as this decision is, I don't think it changes the Dormant Commerce Clause landscape as much as some people thought that this case might ultimately do. We still have the majority of justices saying that it's ultimately really hard and maybe impossible to weigh economic costs of a measure against a state's interest in animal cruelty and public health and things like that, that those are sort of not, that they're apples and oranges, basically. I think, but I think there's some useful language in this opinion. For example, like that pork chop line I had up on the slide, and a few others that show that the justices, even if there weren't any super great sound bites on animal interests being this super pertinent thing for state laws or something like that, it was the background of everything, and the justices made clear, I think, that animal welfare is a permissible basis, maybe among others as well, to pass state laws. And I think that this decision should have the effect of green lighting other similar laws across the country, hopefully emboldening legislatures to, or or citizens in the event of ballot initiatives to pass laws like this, whether it's about farm animal products or puppy mills. Maybe Georgia will get around to that puppy mill bill. Who knows? Because I think it's a huge deal that the Supreme Court of the United States has just okayed this farm animal law. So I don't know that that's a helpful answer in terms of any like concrete strategies, but I think this case will be talked about for decades to come in terms of its positive effect on what types of laws citizens can bring that include protecting their interests in animal well-being, unless Congress wipes it all out with the EATS Act. So stay tuned.
So along the lines of the EATS Act, I was curious, the Solicitor General of the United States submitted a motion for leave to participate in oral argument as an amicus curiae. And that seemed a little unusual to me, but given that the administration did not withdraw its support when we transitioned to the current administration, does it seem like there might be support at the federal level from the executive branch as well as Congress for making a change like this, like the EATS Act?
That's a really good question. I don't think so. You're totally right that the Biden administration surprised us by not withdrawing and then sort of doubling down in some ways on a brief that the Trump administration had filed in the NPPC case. I think though, and it's maybe like a sort of a longer discussion, but that there was some sort of technicalities in there. It was more, I don't think that the Biden administration was signaling in any way that they have a huge appetite for overriding states' rights. I guess anything is possible, but I think a lot of it does have to do with the fact that it was the same Secretary of Agriculture in charge in both. That brief was sort of a carryover from that.
It was a former governor of Iowa, if I'm not correct, Vilsack.
Was Vilsack the former governor of Iowa? I don't know, actually.
I think so. I actually lived in
sounds
Iowa for a
right.
while. Pretty sure, yes.
Yeah.
Yes.
Yeah, I'm not overly concerned about it, I'll say, but it is definitely something to at least look a little bit more into and keep in mind. Yeah.
All right. I don't see any more questions in the chat. Jackie, do you have any more questions that you'd like to ask?
Yeah, I know that we said we're gonna leave the heavy constitutional law stuff for the later panel, but I did want to ask if either of you have an opinion about the case outcome. Were you hopeful, or did you think that the case was going to be reversed and remanded with instructions to do a Pike substantial burden analysis? Like, were you actually surprised by the outcome and also by the justices who made up the majority?
Great question. Megan, do you want to start or? Okay, I'll start. I can't say I was, well, no, that would be a lie. I was surprised for sure that seeing the word, sort of at the top of the page, just seeing the word affirmed was the kind of moment where I refreshed my computer screen several times, like the right window and the right case. It was kind of overwhelming that way. I think, although I was optimistic that we had sort of put our best foot forward in terms of having something in our brief for all of the justices that they could latch on to get all 9 to vote in our favor, with this court and really with any court, it was incredibly surprising that all 9 voted in favor of us on the primary claim. And I did think that there was at least a strong possibility, I'll just say, that part of it, the case could have gotten sent back down to the district court, as you said, on the Pike claim. That's the substantial burden claim. And I think if that had happened, we still would have seen it as, you know, not the most positive development, but not something that we couldn't overcome. I think the way that the sort of market forces have played out thus far is only getting better and better in terms of sort of the on the ground facts that this law is not having the substantial burden on interstate commerce that the pork industry is screaming about. And so ultimately sort of a trial on that would have, I think, gone fine. But yeah, it was surprising to get as affirmative sort of a stance on all of this as we did. And I think in terms of your question about any surprise about particular justices, some of the ones that I and my team were not surprised about are ones that I think might surprise some people who hadn't maybe been as seeped in the Dormant Commerce Clause sort of jurisprudence that we all have been over the last few years. So for example, you know, we knew that Thomas and Gorsuch sort of had no appetite for all of this Dormant Commerce Clause nonsense. And that when we saw that it was Gorsuch who had written the opinion, we knew there were going to be some good nuggets in there for us. But I think that would surprise a lot of people to see that maybe Thomas especially had voted in favor of this this sort of animal welfare law from hippie California, if you will.
Right.
But I think, you know, for example, just one more example, Barrett, I think might have surprised some people on this as well, but her decision made a lot of sense to me. You know, I thought she was very thoughtful in the way she sort of considered whether you can weigh, you know, these sort of incommensurate things, as she called them, this, you know, morality issues against dollar signs kind of thing. So I was pleased, but not altogether surprised that we ultimately got her on that. Good question.
Yeah, I was going to say, as a also a civil procedure professor,
Yeah.
you know, I want to make sure everybody understands, you know, this was dismissed for failure to state a claim, right? At the district court level. And, you know, those don't happen that much. You know, you don't see cases get dismissed for failure to state a claim that often. And so, yeah, there's always the risk that, you know, when you get to the higher court, that they're going to say, well, you know, you need to do this, you know, the Pike analysis. So I think I was a little bit surprised that didn't happen, because again, given kind of the, you know, given it being hippie California, given the nature of the law, I think I was a little bit surprised. And yeah, this opinion is definitely strange bedfellows. You know, again, maybe not from a Dormant Commerce Clause perspective, but definitely from the way that we see the justices leaning and aligning. It's definitely a really interesting opinion. And also I will say that the dissenting and concurring opinions are also really interesting reads as well, and ones that I think we may, you know, need to pay attention to in the future.
Yeah, I was reading Justice Kavanaugh's last night again, and I thought, wow, there's a lot that could possibly happen here going forward. So that's not over.
Yeah,
well, we are. Oh, go ahead. Sorry.
So I'll just very quickly, I will just mention that, you know, in addition to this case, there are still 2 other pending challenges currently against Prop 12. So it is not over. There's that NAMI case I mentioned, still has a little bit of it alive, that's in the lower court. And the Iowa, there's a case from Iowa as well that is still live. So it has some slightly different constitutional claims.
Interesting. All right, we'll have to monitor that. All right, so we're at the top of the hour. I can't thank you enough. This was fascinating, very educational. I'm glad we recorded this because I want to listen to it again. And thank you so much.
Yeah, thank you for having us, and thanks for coming, everyone.
Thank you.
All right, have a good day.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.